Hello, this is the time set for Luba number 2025-018. I'm Board Chair Zamudio. Board members Wilson and Basham are also present today. And thank you for muting your audio when you're not speaking. That helps with our recording and background noise. I'm not aware of any pending matters in this appeal. Do the parties have anything that they need to bring to our attention? No, thank you. Petitioner oral argument is a total of 30 minutes, and you have 15 minutes and may reserve up to 5 minutes for rebuttal, which is the time that you would have to respond to the city's argument. Do you want to reserve any of your time for rebuttal? And you're on mute, petitioner.
Yes, I would like to reserve some time for a rebuttal.
How much time? You may reserve up to
5 minutes.
So just to note, the clock that's on the screen is not keeping exact time, but is there for reference. I'll be keeping track of time, and I suggest that you also keep track of your own time so that you can reserve that 5 minutes. And then the city will have 15 minutes to respond, and then we'll go into the rebuttal.
So can I just ask you to clarify? I have 10 minutes to go ahead and make my argument and 5 minutes reserved for rebuttal?
Correct. So you'll have 10 minutes to do your primary presentation, which needs to be limited to material that's in the brief. And then the city will do their argument for up to 15 minutes, responding to your argument. And then you'll have an opportunity at the end to do 5 minutes of rebuttal, responding to the city's argument. Okay, well, with that, then we will just go ahead and get started. So please state your name for the record, petitioner, and begin.
Yes, my name is Key Lee. Last name is spelled L-E.
Go ahead.
So basically, I think the argument is multiple. The city didn't give us any notice at all, including all the other owners. They were very aware of who we were. We had actually been talking to them for months. The belief is that they held us in limbo, went ahead and moved forward with a ordinance without any notice of the hearings. None of us were notified of the planning commission hearing or the ordinance that evening. I believe that their main argument is that I didn't have standing, which is interesting because their argument is that I showed up, so I wasn't prejudiced. But again, I wasn't given any notice. The fact that I wasn't prejudiced, although they're claiming I didn't argue at the right time of the hearing and didn't make any arguments, was because I had no idea that the hearing was being held. The issue with the emergency hearing, I think that's pretty obvious what was going on there. Again, they claim there was an emergency on their ordinance that so many of us were interested in the food cart pod business, although none of us were notified about the hearing. So that kind of conflicts with what they're saying is that there was need of an emergency, but none of us were noticed. So why would we have an emergency? I think the other issues that we have is that the ordinance itself doesn't list what those emergencies are as far as where their findings were and what the actual emergency was. They had two conflicting ideas. One was for the health and safety, but they didn't list exactly what that was. They also didn't list their findings on why they needed to go ahead and put an emergency on so that we could all move forward. The fact that they originally are trying to, their only argument really is my standing, is whether or not I had standing to go ahead and even make the appeal. I think they don't realize that this isn't about me. It's really about the ordinance itself and how they didn't notify anybody. So when they sit there and talk about my standing, in reality, I have standing because, again, I was somebody that was interested. I have a food cart pod. They knew about my food cart pod. In the first planning commission, they spoke about notifying, they knew who we were. So other than that, really standing and notice. They didn't give us notice. They didn't notify what the emergency was. They didn't notify me after I was in the hearing. Again, the ordinance was put forward as an emergency, and there was no emergency that they listed. And that's pretty much it.
Did you want to talk about anything else, or was that your primary argument?
Well, everything I put in the petition, but yes, my primary argument.
And it's totally okay to stand on your petition. I think that's what you're saying.
Yes, thank you.
Great. So we will turn to the city for response. Petitioner, if you can mute your microphone while you're not speaking, and then after the city's response, we'll return to petitioner for rebuttal. So counsel for the city, please state your name for the record and begin.
Good morning. I'm Shelby Rahala for the City of Tigard. So I want to reorient the board to the facts on this case. Petitioner has mentioned several times about all the other food cart owners and all of the other people involved. He is the only one that has appealed. Tigard has successful operators of food carts all over the city. This is not about them. This is about petitioner and this one specific ordinance. A statement that he did not receive notice. As I said in the petition, he was not entitled to notice. The city properly filed notice of the council hearing of the planning commission meeting with our agendas as we usually do, as the law requires. There was no additional notice required. There was no Measure 56 notice required. There was no newspaper notice required. The city followed all the appropriate procedures. Additionally, even if the city hadn't, he would have to show substantive prejudice. He was at the council meeting. He timely appealed the ordinance. And so he cannot show substantive prejudice, even if he was entitled to notice. The
I have a
emergency.
couple of questions on this.
Yes.
So, with respect to the petitioner's assertion that the city was required to publish notice in a newsprint paper, I didn't see in the petition that cited a statute that requires that. Are you aware of any requirement there? And I think the code itself says publish, but doesn't specify the manner of publishing. Is that accurate?
Yes, correct. And the city's code actually deliberately removed the newspaper notice requirement several years ago when we updated it. So no, Measure 56 is the only generally applicable notice that potentially could have been required.
And that was my next question, was on Measure 56. What is the city's position for why the Measure 56 notice was not required in this case?
So this case actually expanded opportunities instead of limited them. It was not a zone change. It did not restrict any activities that could have previously or would have previously been allowed. So it actually just clarified the processes by which food carts and food cart pods could be developed. So it didn't.
Were there any previous regulations for food carts before this ordinance was adopted?
Yes, there were.
So is this ordinance amending those regulations, or was it adding regulations?
It was mainly amending and clarifying the processes. There was some gaps in when overlapping code amendments were presented. There were some gaps created in terms of food cart regulations. So this filled in the gaps and clarified how they could be developed and what process they'd follow.
So I think you're being careful by saying filled in the gaps. Did it add any additional regulation, or was there were no regulations covering what these amendments did? I'm trying to understand. I think petitioner's position is this ordinance is adding new land use regulations to food carts where there were none before. And so under the Measure 56 statute, these are additional limitations. So Measure 56 notice was required. I'm trying to understand what the ordinance does exactly to get some sense of that issue.
Right. So yes, there were previous requirements.
In the same section of the code?
Yes.
And those are not zone specific, or I imagine food carts are allowed in certain zones and not allowed in other zones.
They are not zone specific in the ordinance. But yes, they are allowed in some zones and not others. I'm trying to flip to the record. So previously, so it largely consolidated the standards that we previously had in a couple different places. The previous code had no standards or approvals for food. So prior to what we call our Tigard Made code, there were no standards or approvals for food carts. That code was amended, I believe, in 2024. And then food carts were allowed through code and a policy interpretation. So what we allowed is actually a process for food carts as a standalone use that had not previously existed. So development, one of the reasons for the emergency clause was to fast track this approval process, because previously food carts were largely not allowed, or they were allowed as a temporary use process.
Is it the case that the pre-existing regulations were not part of the zoning code, the city's land use regulations, or were they?
They were, yes. It was the same code that was amended.
So they were part of the land use regulations.
Yes.
The petitioner's saying that before the ordinance, he could have a lot of food carts, and now after the ordinance, he's restricted to 3. Is that correct or not?
No, that is not correct.
And why is that?
So there was no process by which the city would have allowed 20 food carts.
Not even 4 food carts?
So the previous regulations were mainly limited to 3 food carts.
Is there anything in the record where we can look at that to see what the limitations were on the number of food carts before the ordinance and what the number of limitations on the food carts were after?
Yes. So looking at the code package, So the actual text of the regulations, so it starts on page 12 of the record. So 18750 was the food cart chapter, and you'll see that, so page 12 is the clean version, it looks like. So 18440 removed food carts from the temporary use provision and moved them into the standalone chapter. So yes, starting on page 12 of the record, and then the changes to 18440 are on page 19 of the record. And to respond to one of the earlier questions, it's actually the new regulations that expand the opportunity to go up to 20 food carts. The previous regulations were limited to 3. So again, this actually was an expansion and a clarification. It was not a limitation.
So that's the city's position for why Measure 56 notice was not required, because your position is that these amendments do not limit or prohibit uses that were previously allowed in the affected zones.
Correct. The previous uses were much more limited. This created the process by which they could develop.
Thank you. That answers my question.
Thank you. And then the emergency clause, as stated in the city's argument, that was information about the justifications for that was provided both in the ordinance and at the hearing itself. Case law gives a lot of deference to local government in justifying that, and the city has more than met its burden on that. And if there are no other questions, I will rest on the city's reply brief.
No further questions from the board. Thank you for your argument. We will return to petitioner. You will have 5 minutes for your rebuttal.
Yes, I think that's a little bit of misdirection, maybe. So the Tigard Made was a temporary use food cart ordinance that limited the carts to three carts. Prior to that, there was a rule, and that's the one that I actually operated, and the other three food cart operators operated on, was a rule, I guess. It wasn't in the code, but we operated with the understanding that there was no limit. Actually was working with planning. I had planning approval. I had my business plan prior to that. But the idea that they can move an ordinance from temporary use and create a whole new chapter. In fact, they actually took that chapter away from another chapter, included other parts of it, the food cart pod, and more restrictions on that. The Tigard Made, which he refers to, was never repealed. It was just literally eliminated and then moved to a whole new section and then added a number to it and some rules to it and then applied to us through emergency clause. Again, whatever they want to justify the emergency clause, the only 2 things that are listed on that ordinance is for the health and wellness, safety, but they don't talk about anything what created that. There was no time limitations on that emergency, and then basically they're claiming it was because we all were, applications were waiting and they wanted to move us forward. But then why the emergency? And obviously I can't talk about a lot of things that have happened since then that pretty much show that this emergency was BS. But
I want to understand for the Measure 56 assignment of error, what your position is on what this particular ordinance does, these amendments to the development code do to limit or prohibit uses that were previously allowed. What are the new, in your view, what are the new limitations or prohibitions that didn't exist before this ordinance?
So again, the Measure 56, I had a contract to purchase the property, but none of the landowners actually got any notices. There's no notices that are listed. So there was no notice to anybody, regardless of whether it's to me. So the provision for me was prior to the Tigard Made, I had actually been in operation, was working towards in development to develop the 20 carts. I had approvals. We actually went through the city to talk about stuff. And then Tigard Made happened in May of 2024, and everything was great. And then all of a sudden, somewhere in September of 2024, they decided we all can only have 3. We're in violation of any more than that. I had 5. They held us in limbo while they secretly together this ordinance. I just got last minute notice. Hey, look, talking about food cart.
So I just want to slow down. I just want to understand your position is prior to these amendments, the law, wherever it was allowed more than 3. And so these amendments change that by allowing only 3. That's your position.
Plus, they added development charges and that were not there. Significant system development charges.
Okay. Am I correctly understanding what your position is, that there were more than 3 were allowed, and then this amended thing to allow 3? That's your position?
Yes.
Thank you. Go ahead. You still have some time.
Okay, pretty much it. Prior to Tiger Made, they completely forget about that there wasn't a rule and that we followed those rules. And then they used Tiger Made to shut us down because they knew that Tiger Made didn't target food cart pods. It only limited to 3 carts. So they didn't have a food cart pod section. So for them to sit and say, look, this is an amendment, but they took that out of temporary use and created a whole new section, which I think would require that the prior section needs to be repealed, and I think there's things that need to be done to put a whole new section, including notice. And that's pretty much it.
Okay. Thank you both parties for your argument today. That will conclude oral argument. The statutory due date for our decision in this appeal is December 4th. We'll ask the parties in advance to agree to an extension so that we can issue our opinion no later than December 18th. Does that work for these parties? I see agreement.
Yes.
Okay. Thank you very much.
Thank
Have
you.
a good remainder of your day.
You too. Thank you.